Friends, welcome to the 43rd edition or session of Legal Empowerment Through Interaction lecture series. Today, we have a wonderful speaker, Adv.P.T.Mohankumar sir. He'll be addressing on the testamentary capacity, the wills, and on the nuances and the doubts we have expressed in the last session. And for the moderation or for introducing the subject, we have Justice Sasidharan Nambiar sir. We also welcome Justice Ramkumar sir, Justice Chidambaresh sir, and Justice Kamal Pasha sir, and all of you. Let us over to Justice Sasidharan Nambiar sir for the introduction of the subject.
Good evening to all.
Good evening.
Hope I am audible to all.
Yes, audible and visible also.
Yes. See, I am only expected to introduce the subject.
That's all.
See, am I expected to enlarge everything or just to speak on?
You have to leave something for the speaker.
Absolutely, sir.
See, a will is the statement made by a living person to be acted upon after his death. So, when the will comes into effect, the testator, rather the author of the will not be available. So, the question of proof of will is rather complicated. Section 68 of the Evidence Act, which relates to the documents which are required to be proved, are made applicable to the proof of a will under section 68 of the Act. The writing of will is normally required or adopted to give the property to the legatees or others also. When one of the legatees or some of the legatees are preferred and others are excluded, naturally there will be dispute for the loss of the property which otherwise would have been there on the death of that testator. If the property is to be given to the successors in accordance with the succession law, normally there may not be a necessity to execute a will, except for avoiding conflict between the legal heirs as to the particular properties. The very purpose of the will in most of the cases would be to give the property not exactly as provided under the law of succession. It is for that reason the will is being questioned when it is propounded. When the will is sought to be enforced by the legatee, the burden of proof assumes importance. It is for the propounder of the will to prove that it is executed by the testator of his free will and volition. The nature of evidence as regard to a will is special, being one of the most solemn documents known to law, and the dead person cannot come as a witness, comma, it is necessary to prove the will as provided under the law. Section 3 of the Evidence Act shows the meaning of proof to be that the fact is proved when the court, after considering the matters before it, either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that the party who applies for probate or put the will has to prove that the will was executed as provided under the law. It is to be proved that the testator executed the will in a sound disposing state of mind, and he understood the contents of the will and of his free volition executed it in the presence of two attesting witnesses, and at least one of the attesting witness is to be examined as a witness to prove the will if the attesting witnesses are alive. The question is, has the testator signed the will? Did he understand the nature and effect of the dispositions in the will? Did he put his signature to the will, knowing what it contained? It is the decisions on these questions which determine the nature of the finding on the question of proof of will. It would prima facie be true to say that the will has to be proved like any other document, except to the special requirements of attestation provided under Section 63 of Indian Succession Act. If the execution of the will is surrounded by any of the suspicious circumstances, then it is for the propounder to explain away such circumstances. At the same time, if the will is objected to on the ground of fraud or undue influence, then it is there exist such circumstances, and therefore the will is not the result of the free exercise of the will or execution of the will by voluntarily, is on the propounder of the will. Therefore, these matters are important, and I hope the day speaker will take over and explain all these aspects in detail. Thank you.
Thank you, sir. My warm greetings to all. The subject is the paradigms of testamentary freedom. Of course, my own observations and my study, it may be faulty, I may be excused. I may start with the words of Jeremy Bentham, who beautifully explains what is a will, or what is the effect of a will. Let me share my screen. The power to make a will an indefeasible right of the owner of the property. It is for each proprietor who can and who ought to know the particular circumstances in which those dependent upon him will be placed upon his death, to correct the imperfection of law in all those cases which it cannot foresee. The power to make a will is an instrument entrusted to the hands of the individual to prevent the private calamities. Very beautifully explained. So that gives an answer to what is the nature of a will, what should be the nature of the testamentary disposition that a testator can choose. It is to keep the natural line of succession at bay that a will is executed. The learned speaker who moderated has explained the principles. The viewers would remember that in the last session I have made the principles, I explained the principles. But anyway, by way of recapitulation, I may just refer those principles, how a will is validly executed. Shyam has already explained, but still, this is the sum and substance of my how a will is validly executed. A will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will. Each of the witnesses has signed the said will in the presence of the testator. The attendant circumstances shall not give rise to suspicion. So many decisions, but I am citing only a few. That is 2013 7 SEC 490. When we go through the judicial pronouncements, nobody can leave an important decision, a celebrated decision, that is 1959, AR 1959 Supreme Court 443, H. Venkatajalaya versus N. Themmajamma. Of course, it is a forensic analysis of the law of wills, how a will has to be validly executed. The great Justice Gajendra Gadkar has beautifully explained the evidentiary value, how a will has to be proved, how the disposition has to be treated, everything. But I am not relying on those rulings, but I am just pointing out this ruling just to show the paradigm shifts rather that has evolved during the period. Of course, a will has to be attested. We will come to it later, the intricacies of attestation briefly. Attestation is a process of seeing or the executant or the testator executing a document. It is having more ramifications in law. I will explain it later. The animus to attest, if not available, there is no attestation. A scribe is not a witness to the will, but mere writer of the will. His evidence is not acceptable as an attester. 2001-7 SEC 503. Why I said this ruling is that attestation is not just the mere act of putting one's signature into a will, as if we have seen the testator executing the documents. Registration is not necessary for a will because a will is not treated like any other documents. So it may be a document of transfer, but it does not require registration. There is a common belief that by registration, a will gets authenticity. It is absolutely a false belief that is explained by our apex court in AR 1954 Supreme Court 280. And then comes, I discussed this, how a will is to be proved. A will being a document has to be proved by primary evidence, except where the court permits a document to be proved by leading secondary evidence. As provided in section 68 of the Evidence Act, it cannot be used as evidence until one of the attesting witnesses at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence, Daurat Rama and others versus Shobha and others, the viewers may kindly verify there are certain principles. It is, in fact, a digest of the earlier decisions also, 2005, 1 SEC, page 40. The inability to examine an attesting witness, how to be dealt with. If no attesting witness can be found, the will have to be proved in the manner mentioned in section 69. You will get the decision of our Honorable High Court report in 2015 KHC 616 or 2000, and also you may see 2014 2 KHC 304. Then if attestation is denied by an attesting witness, what should be done? So section 71 of the Evidence Act gives an answer to that. Will can be proved by other modes like any other document. That is explained in 2015 3 KLT 740. Anyway, these are just the gist of what I have explained during the last session, so that these principles may kindly bear in mind for the further discussion. I may be excused for 1 second.
Yes.
Hello. See. I'm sorry, I may be excused.
No problem.
Then, what are the features of a valid will? It's a legal declaration of the intention of the testator. the subject matter need not be property. If the subject matter is property, there should be disposition, revocable at any time during the life of the testator. It has been explained by the judicial pronouncements that a will becomes ambulatory only when it is having that feature as revocable. It takes effect at the death of the testator. Then registration is not mandatory.
Again, your sound is breaking.
These are all the now it can be heard. Am I audible?
Yes.
So I explain these the features of a valid will. The freedom to bequeath one's on property is absolute, but it is subjective. His testamentary capacity and his power of comprehension are relevant factors in assessing the enforceability of a will. Interpreting a will is a laborious task where what is to be out is the freedom of the testator and his subjectivity that are the two essential factors to be considered while interpreting a will. Even after proving the execution, the court is under a duty, or the court is under a solemn duty that in several judicial pronouncements it is so explained to consider these facts, that is the testamentary freedom, that the testamentary freedom of a testator and also the testamentary subjectivity. Of course, I may point out that in many judicial pronouncements, these two aspects are not being considered properly. I may not be taken amiss. I am only pointing out from my observation that testamentary freedom and testamentary subjectivity are the two propositions to be accepted by courts in interpreting a will. I am explaining, or I am trying to explain these aspects in today's talk. Although freedom to bequeath, I was trying to point out that although freedom to bequeath one's own property is absolute, both in choosing the legatee, even if he be a rank stranger. Why I am pointing out this is that's the principle that has been accepted by our apex court in AR 1990 Supreme Court, page 1742. Ram Gyari versus Bhagavad and others. The apex court has pointed out certain aspects. Testamentary capacity or a disposable state of mind of a testator is required to be proved by the propounder, and he has to establish that the testator at the time of disposition knew and understood the property he was disposing and persons who were to be the beneficiaries of his disposition. Prudence, however, requires reason for denying benefits. I am underlining these words, reason for denying the benefits to those who too were entitled to bounty of the testator, as they had shrouds that disposition with suspicion, as it does not give any linking to the mind of testator to enable the court to judge the disposition was voluntary act. Here, I may add a word that, with great respect to the apex court, in this ruling, the apex court has laid down a principle that the reason for denying the benefits, that was to be underlined, reason for denying the benefit. Of course, I may point out that the law that has been universally accepted and followed by English
Your voice is breaking.
American courts and Australian courts, where at the courts which follow, sir, Nitinda. Am I audible now?
But
Okay.
the voice is breaking. Voice breaking.
Just 1 second. 1 second. Am I audible now?
All right.
Yes.
Sorry, I will 1 second repeat. That is, the Apex Code has laid down that the reason for denying a benefit is also a point to be looked into. I was explaining that is, with great respect, I may submit that it is not at all necessary to go into the reason of a testator, why he denied or why he kept at bay the natural line of succession. That is the testamentary freedom of a testator, which cannot be interfered with, and it is also his subjectivity. He may be having his own reasons why he did not bequeath to his sons or daughters, why he preferred his belief. He did not explain in the will. So that what I am pointing out is that this is one of the rulings, and there are other rulings also. So how far this can be taken as a rule of law, that is what I am trying to explain.
Yes.
1925.
Again there's a breakage of sound.
It's really a problem. It's really a problem. Am I audible now?
Yes, now you are audible.
The testamentary freedom that was curtailed in India by virtue of the principles of the personal laws of the parties. In Mohammedan law, the testamentary freedom has to be examined vis-a-vis the law set out in Hidayah of Shariat that imposes a restriction on testamentary freedom. A Muslim cannot make a bequest more than 1/3 of his estate. No natural legal heir can be deprived of. Although there were legislations in India, there was no uniformity in the laws of wills until the Indian Succession Act was enacted in 1925. Even after that, Mohammedan law continues to be followed by the Muslims. Now in India, except Muslims, other religions like Christians, Hindus, Buddhists, Jains and Parsis are governed by the Indian Succession Act, and they enjoy the testamentary freedom. As far as the Hindus are concerned, the provisions of the Indian Succession Act are applicable subject to the exceptions set out in Schedule 3 of the Act, which is having some historical reasons. I am not explaining it now. So these are all necessary for explaining it. And for Hindus also, the Ajnavalkya text that dealt with testamentary gifts. A Hindu can give a testamentary gift only without ignoring the natural legal heirs, or rather his family. So there were restrictions earlier, but Indian Succession Act after its enactment, or rather the new Succession Act enacted in 1924, that gave absolute freedom to a testator. Now, let us consider what are the types of wills, or the kinds of wills. They are privileged and conditional or joint wills, concurrent wills,
Again, sound is breaking.
duplicate wills. Then holograph wills. Then another category, though it cannot, that is for being executed, that is sham wills. Let us examine which are those wills. A privileged will. Any soldier being employed in an expedition or engaged in actual warfare, or an airman so employed or engaged, or any mariner being at sea, may, if he has completed the age of 18 years, dispose of his property by a will made in the manner provided in section 66. Such wills are called privileged wills. Unprivileged wills. We can simply wills which are not privileged are unprivileged wills. But still, section 63 of the Indian Succession Act may be looked into. It defines an unprivileged will as every testator not being a soldier employed in an expedition or engaged in actual warfare, or an airman so employed or engaged, or a mariner at sea shall execute an unprivileged will. Then conditional or contingent wills. The wills, those take effect only in the event of satisfying certain conditions or contingent upon something. That become valid only in the event of the happening of some contingency or condition. If the contingency does not happen or the condition fails, the bequest becomes invalid. Please refer sections 124 and 131 of. There is a ruling of our Honorable High Court, that is, with reference to section 134, what are the criteria to determine whether a will is conditional or contingent, that we get it in 1915 and KLT 528, Sridevi, alias Malathi and others versus Venkata Parashurama Iyer. So I am not explaining those. The features, it is very clear. Then joint and mutual wills. Of course, I keep it in mind that I have to explain it, but I may explain it later. But still, I may point out the features. Two or more persons agree to make it. That take effect after the death of both persons, not operative during the lifetime of either. The one who survives can revoke it. That is, the distinction between a joint and mutual will, that is often confusing, whether it is joint or mutual. We can only explain it, whether it is joint or mutual, with reference to the recitals and the intention of the testator. The distinction between a joint and mutual will is explained by the Apex Code in Dr. K.S. Palanisamy through LRs versus Hindu community in general and citizens of Gobi Chettipalayam and others. AR 2017, Supreme Court 1473. A question was put to me. I may just explain in simple words that a joint and mutual will, that is to be considered with reference to the recitals if it operates as an agreement between the executants, the testators, in between themselves. That contract should prevail. That is, if it is a joint will, it can be that it can survive the death of one testator, provided that is the intention of one of the testators. It is accepted by the other. I will explain it later during the interactive session. Then duplicate wills. For the purpose of expediency and for convenience, wills are executed in duplicates. A duplicate of the will made for entrustment with a bank or an executor or a trustee, and the testator keeps one copy with himself. An important feature of this duplicate wills is that if the testator destroys the will in his custody, then the other also stands revoked. Then we comes to sham wills. It need not be even considered as a will because the intention of the testator is otherwise. It is not a legal declaration that he doesn't want it to be a will, but still that category is being approved not as wills, but some document for some collateral purpose. The features of such sham wills: the document executed styling as a will without any intention to make it operative. So the first condition, that is legal declaration of testator, made by fraud or coercion or by taking away the free agency of the testator, of course, that again would make it an invalid will. Just a show of a will, but not a will intended to make it effective, then executed for collateral purpose. Then holograph wills. Of course, holograph wills may be having future. I may explain. It is written in the own handwriting of the testator. Law makes a great presumption in favor of the genuineness of a holograph will. The burden is on the proposer to show that the document is a holograph will written in the hand by the testator himself. What is required is to formally prove the will, and very little evidence as regards execution and attestation is called for. There is a greater presumption of regularity and due execution in the case of holograph wills. Please refer to a ruling of our Honorable High Court, report in 2017 2 KLT 144. That is relying on a ruling of our Apex Court reported in 1996 9 SEC 324, Joyce Primrose Prester versus Vera Mary was and another. So the holograph wills now being accepted universally as an authentic will because it is in the own handwriting, and in some countries attestation is not given so much importance or weightage if it is written in the handwriting of the testator himself. In India also, this is being legally recognized because the handwriting of the signature is there. And it gives authenticity to the will. Then we come to the important aspects, that is testamentary capacity. Section 59 of the Indian Succession Act deals with the testamentary capacity of a testator. Every person who is of sound mind, not being a minor, may dispose of his property by will. That itself is not testamentary capacity. That is only one aspect of it. It is soundness of mind and attainment of majority. But sound mind of a testator has to be explained. It is the competency to understand as to the nature of his property. It is his capacity to identify the kindreds to him. It is his power to deliberate in whose favor it would be proper to make a bequest. It is his capability to exercise a judgment as to the proper mode of disposing his property. It is his ability to understand the nature of the instrument. Over and above all, he shall not be feeble-minded or debilitated. The testamentary capacity, the judicial review that I am citing a few examples. The freedom to bequeath one's own property is absolute, but it is subjective. His testamentary capacity and his power of comprehension are relevant factors in assessing the enforceability of a will. Please refer to 2002 to SEC 85, Madhur D. Shende versus Tarabai Abba Shende. And again, if after considering the matters before it, that is, the facts and circumstances as emanating from the materials available on record of a given case, the court either believes that the will was duly executed by the testator or considers the existence of such facts as probable that a prudent person ought, under the circumstances of that particular case, to act upon the supposition that the will was duly executed by the testator, then the factum of execution of the will shall be said to have been proved. One who propounds a will must establish the competence of the testator to make the will at the time when it was executed. Before going further, I may request you to consider section 3 Section 3 of the Evidence Act. Section 3. Section 3(2), facts. Fact is defined as including no, any mental condition of which a person is conscious. So that when we say that what has to be proved when a will is concerned, it is the mental condition of the testator. That is a fact. Mental condition of a testator is a fact. That is what has to be borne in mind while analyzing this principle. Although freedom to bequeath one's own property is absolute both in the extent and person, including to a rank stranger, yet to have testamentary capacity or a disposable mind, what is required of a proponder is to establish that the testator at the time of disposition knew and understood the property he was disposing in persons who were to be beneficiaries of his disposition. Prudence, however, requires reason for denying benefit to those who too were entitled to bounty of testator as they had similar claims in him. Absence of it may not invalidate the will, but it shrouds the disposition with suspicion, as it does not give any linking to the mind of the testator to enable the court to judge if the disposition was a voluntary act. The proponder of the will has to show that the will was signed by the testator, that he was at the relevant time in sound disposing state of mind, that he understood the nature and effect of the dispositions, and had put his signature to the testament of his free will, and that he had signed it in the presence of two witnesses who attested in his presence and in the presence of each other. I may once again point out that it is a question of facts. It's a fact to be proved. It is a mental condition which is a fact. Or precisely, that is what is to be proved when will is sought to be admitted. Let me try an analysis of these rulings. The traditional doctrinal requirements for testamentary capacity, based on factors like knowledge of his own property, the act to be performed in making of the will, and the objects of one's bounty alone cannot serve as guidance for fixing a statutory standard of sound minds. The courts have struggled much to articulate precisely to lay down the principles for ascertaining testamentary capacity of a testator by drawing a line for distinguishing a competent testator from an incompetent one. Two paradigms that can be shown from the judicial reasonings that may be examined. The first is a test, that is whether the testator can be found to be rational or to have exercised reason. This test is an objective one, in the sense that it looks towards an abstract ability which anyone can recognize as one may possess. The second test is the focus, though not directly on the testator's ability to reason, but on his consistency with his own self. The testator is required to have made a will reflecting his own unique belief and experience in the family relationship. The concept of self-consistency needs to be assessed objectively as his recognizable ability from the evidence and stepping into the testator's shoes in order to see through his eyes what is reasonable for him to decide about the bequest. There are restrictions on wills, statutory restrictions that we will get it in section 112 and 130. A bequest made to a person not in existence at the time of testator's death is void. If a bequest is to an unborn, a prior interest for life has to be created in favor of a living person. Such bequest must comprise of whole of the remaining interest of the testator, so that a testator, when he is choosing a legatee, an important aspect is that that person should be in existence. Or if somebody is in existence and he can provide a legacy during his lifetime, and after that it can be given over to the successor, though unborn. Then there comes the rule against perpetuity. The rule against perpetuity invalidates first vesting beyond the life or lives in being and the minority of the legatee who must be living at the end of the last life, that is section 140, succession rights. Then there are invalid wills. A will or any part of a will made which has been caused by fraud, coercion, and undue influence, referred to section 61. Then uncertainty, section 89. Non-happening of contingency, section 126. Illegal and immoral purpose, section 127. So these are wills which are liable to be invalidated. Then I may come to the language of wills. I may just point out that a common feature of wills, we see wills which are prepared by scribes. The scribes, no, I am not putting any blame on a class. They are professionals. But of course, some or many among them are not having the practical legal knowledge. They may use a language which may be, according to them, perfect, but it is not the language of the testator. The professionalism cannot be exhibited in wills. Professionalism in the usages and expressions should be avoided. That's AR 1990 Supreme Court 1742. That decision may kindly be referred to. Our apex court also had occasion to consider this aspect. It was a recent decision that I may just come across this. I just came across that decision. That is, I will come to it later. Let us consider the testamentary subjectivity. No one can make a will except to prevent the operation of some law of descent. That's a common law principle. Bret-Heft versus Cleveland. Then the principle in Coleman versus Robertson's executors. Indeed, freedom of testation means that the testator has the right to make a will disposing of his property as he may see fit. Courts recognize that even a wise person can be capricious in the disposition of his or her property. In India also, the above principle is followed. I may draw your attention to the ruling reported in 2004 2 ACC 321, Mahadevi Nambiar and others with TCC. Please bear with me for a moment. There is a maxim that is usually applied for interpretation of the wills. Omnia presumpta, right, esse acta. If a will on the face of it appears to be duly executed, presumption is in favor of the due execution, applying the principle omnia presumpta, right, esse acta. The force of the presumption varies with circumstances. If the will is entirely regular in form, it is very strong. But if the form is irregular and unusual, the maxim does not apply with the same force. We'll get it from a passage of Williams on wills at page 71, second edition and 60. This principle is accepted by the Apex Court in 1996, 9 SEC 324, and it is followed in several decisions thereafter. All things are presumed to be done in due form, that is expected. Then, unusual form of a will When a will is proper in form, it is presumed to reflect a serious, genuine, and authentic testamentary intent. That is, we will get it from a common law case, R.D. Hirsch, based on a ruling that is in R.D. Hirsch annotation, weight and effect of presumption or inference due execution. That is an article. But the presumption is rebuttable. This is also a common law concept. Contestants may challenge the presumption raised in favor of due execution by showing inter alia that the testator lacked capacity or did not in the circumstances truly intend the executed instrument to serve as his will. Artificiality can also be pointed out if the will is made in a form which is so strange. There exists grave doubt whether the will deed was executed and is a will as it purports to be. That is the recent ruling of the Apex Court, reported in 2022 MLJ, page 55. Rajkumari and others versus Surendra Pal Sharma. There, on going through the facts of the case, it can be seen that the testatrix was an illiterate lady. The will was in a language which is foreign to the testatrix. It is having the nomenclature of will deed. Even that gave rise to suspicion in the minds of the courts. So the court held that it is not a proper will. Interpretation of the object or subject of the will. This is connected with the subjectivity, which is a statutory condition. Please see section 17. Inquiries to determine the questions as to the object or subject of will for the purpose of determining the question as to what person or what property is denoted by any words used in a will. A court shall inquire into every material fact relating to the person who claimed to be interested under such will. The property which is claimed as a subject of disposition, the circumstances of the testator and of his family, into every fact a knowledge of which may conduce to the right application of the words which the testator has used. So, a principle of interpretation of the will that we get it right from the ancient days. I refer to a fable, Aesop's fable about the will. Maybe it is a myth, but the common law accepted that. Let us see that principle followed in Robertson versus Robertson's executors. It's a case, it's a celebrated case where every aspect of a will are examined. When construing a will, extrinsic evidence is admissible not only to remove ambiguity in the language used, but to establish the testator's situation at the time of the will and the context in which he expressed his testamentary intention. James L.J. said that when in interpreting a will, the court should place itself in the testator's armchair. This principle is followed by our apex court in AR 2009 Supreme Court 1194. If the court is to put itself into the testator's armchair to ascertain his position from the words used in the will, it must take into consideration the surrounding circumstances, the position of the testator, his family relationships, and attach importance to isolated expressions so as to give effect to all the clauses in the will, some of it inoperative. Of course, some harmless mistakes will not render the will invalid. Misnomer or misdescription of objects is of no consequence if the purpose of the testamentary purpose or the intention of the testator is discernible from the will. Were the words used in a will to designate or describe a legatee or a class of legatees sufficiently show what is meant, an error in the name of description shall not prevent the legacy from taking effect. A mistake in the name of a legatee may be corrected by a description of him, and a mistake in the description of a legatee may be corrected by the name, section 76. You will get illustrations also. When words may be supplied. The missing words can be supplied. But of course, it should be in accordance with the statutory condition laid down in section 57, where any word material to the full expression of the meaning has been omitted. It may be supplied by the context. Then, rejection of erroneous particulars in description of subjects. If the thing which the testator intended to bequeath can be sufficiently identified from the description of it given in the will, but some parts of the description do not apply, such parts of the description shall be rejected as erroneous, and the bequest shall take effect in section 78. In the interpretation of wills, the courts can look into extrinsic evidence. Because I may once again explain, in my last session I pointed out evidence may be intrinsic or extrinsic. Intrinsic evidence is what is provided by the document itself. Extrinsic evidence relates to circumstance, or it parole evidence also. Extrinsic evidence, when words of a will are unambiguous, but it is found by extrinsic evidence that they admit of application, only of which can have been intended by the testator. Extrinsic evidence may be taken to show which of these applications was intended. Where there is an ambiguity or deficiency on the face of a will, no extrinsic evidence as to the intention of the testator shall be admitted, because it cannot be corrected at all. If there is an ambiguity, basically it is there, or deficiency is there, it cannot be corrected by whatever method, even by supplying notes, by looking into extrinsic evidence, or by the evidence of witnesses, because the testator intended that. And just to get rid of the boredom also, may invite your attention to a will of the great Shakespeare. Many of the viewers would know about the will of Shakespeare. It is very famous, just like his works, his will also. Shakespeare, the Lord of Words, he knew because in his classic works, he dealt with the rules of kingdom, and he, in his will, bequeathed every valuable property to his next of kin, except his wife. To his wife, he gave a bed. He explained it as my second best bed. Of course, he was assisted by a very efficient and expert lawyer of that time. He knew the law. Why he did it? He was criticized for giving a useless bequeath to his wife when the valuables were given to others. Many criticized him as having lost love between himself and his wife. But his intention was otherwise. That was proved later. In England, the common law protects a widow. She can enjoy the properties as life estates, but she cannot have of her husband who is deceased. Shakespeare wanted to provide her with love. So the second best bed was a symbolic bequeath that is now explained as his bequeath. So that what I am pointing out is that the testator may have his own reason. He may know the law. He may know the provisions of law which may protect his next of kin. So court cannot interpret that as a gift which does not stand to reason. the essential rules of construction. The meaning of any clause in a will is to be collected from the entire instrument, and all the parts are to be construed with reference to each other. Section 82. General words may be understood in a restricted sense, where it may be collected from the will, that the testator meant to use them in a restricted sense. The words may be understood in a wider sense than that which they usually bear, where it may be collected from the other words of the will, that the testator meant to use them in such wider sense. Where a clause is susceptible of two meanings, according to one of which it has some effects, and according to the other, of which it can have none, the former shall be preferred. The rule in section 84. No part to be rejected if it can be reasonably construed. Section 85. If the same words occur in different parts of the same will, they shall be taken to have been used everywhere in the same sense. Now, intention of the testator, that is decisive to reconcile repugnancy. Testator's intention to be effectuated as far as possible, where two clauses of gifts in a will are irreconcilable so that they cannot possibly stand together, the last shall prevail. So here, once again I may point out that there is statutory recognition of the proposition of testamentary subjectivity, honoring the testamentary freedom, and only within the parameters set out in the statute, only courts can interpret the will. That is the rule set out. That's the meaning of these rules. That is why I'm explaining it. Obliteration and interlineation, alteration. Section 71 is applicable to alterations if they are made after the execution of the will, but not before it. Any obliteration, interlineations, or any other alteration in a will made after its execution is inoperative unless the alteration is accompanied by the signatures of the testator and the attesting witnesses, or it is accompanied by a memorandum signed by the testator and by the attesting witnesses at the end of the will, or some other part referring to the alterations. The alterations, if executed as required by this section, would be read as part of the will itself. My respected viewers may kindly examine section 71. Of course, it may happen if some unscrupulous next of kin who are avoided by a testator come to know about the execution of a will. At dagger points, he will be threatened or coerced to correct the will, or rather to alter the will. The law protects it. Once a will is executed, no, it cannot be corrected unless it is in accordance with the statutory mode prescribed under section 7. It is also a protection to a testator. Revocation or alteration of a will, section 62. A will is liable to be revoked or altered any time during the lifetime of the testator. Section 70 of the Act provides the manner in which it can be revoked. Revocation. Revocation is also very categorically explained under section 70. It can be done by executing another will or codicil, or by some writing declaring an intention to revoke the same, and executed in the manner in which an unprivileged will is hereinafter required to be executed, or by burning, tearing, or otherwise destroying the same by the testator or by some person in his presence and by his direction with the intention. See, an important aspect that has to be looked into from this provision, that is section 70, the testamentary capacity and testamentary freedom of a testator, that extends to revocation as well, just like execution. He has to do it just like a will is executed. It has to be done in the presence and by the direction with the intention of revoking the same. It can be done by some other person. It can be done by the testator himself. But in whatever way it is done, it has to be done in the same way as execution of a will. Dependent relative revocation. This was a point that has been asked in the last session. Dependent relative revocation is a concept evolved in the common law. I am referring to a portion of Halsbury's. Revocation may be relative to another disposition which has already been made or is intended to be made, and so dependent thereon that revocation is not intended unless that other disposition takes effect. Such a revocation is known as dependent relative revocation. And if from any cause the other disposition fails to take effect, the will remains operative as it was before the revocation. This principle is explained by our Honorable High Court in AR 1962 Kerala 48, and also a full bench decision of our Honorable High Court in 56 KLT 469. So the principle is very clear. The revocation, it is relative to another disposition, which has already been made or intended to be made, and so dependent thereon that revocation is not intended unless that such disposition take effect. Dependent revocation, if from any cause the other disposition fails to take effect, the will remains operative as it was before the revocation. That is, I can explain it that a subsequent will is also executed without revoking the earlier will. But there will be some difference in the matter of bequest in the subsequent will. If it is revoked, the earlier will stands. But that may be with respect to disposition of some specific legacies or some properties which would remain there, and the testatrix have no intention to revoke it. Then that survives. That is the principle explained. Dependent relative revocation. Who can intermeddle with the bequest after the death of a testator? Everything depends on the interpretation of the will and who interprets it. So to avoid such a contingency, an anomalous situation, or rather a situation which is likely to be brought out, that it cannot be given due effect. A testator appoints somebody who is trustworthy to him. An executor is appointed, or a trustee appointed, because a trustee may be required. For example, if the legatee may be a minor, or legatee may be a mentally retarded or mentally challenged person, and for maintaining that person, a trust can be created and a trustee can be appointed. And if nobody is there, an heir of the deceased testator, who can even act as an executor, who can do everything which an executor would do. Regarding appointment of executor, you may remember a story. Many of my viewers may recollect that story. The role of an executor. An executor, if he is unscrupulous, may take away the property, and he may take the benefit out of it. He may deprive the rightful legatee. There is a story of a man, it's only a story, a man who made a bequest to his minor son. He appointed an executor who is a dearest relative of him. The bequest was worded, "Thou shalt give to my son when he come up of age whatever you like in the properties." Story is having a moral also. The executor, who was greedy, he wanted to take the entire property, or rather a substantial part of the legacy, without leaving anything to the minor. The minor became a major, attained majority. Naturally, it ended up in litigation, the interpretation of the will as done by the jury, that is, the executor, he's having an eye on the substantial part of the property. That is what the testator also foresaw, that he may sometimes, if greedy, would do this. So whatever you like may be given to my son. That means he likes the entire property or a substantial part of it. That may be given to the child. Maybe a story. But there are also, in the story also, the intention of a testator, that is to be explained, interpreted in the manner the testator intended to interpret or to give effect. Executor means a person to whom the execution of the last will of a deceased person is by testator's appointment confided. Section 2C. Here, very important aspect is that it's a confidence, it is indicated. Executor is a person of confidence. The very definition implies it, confidence. That is the confidence. Both the testator is having confidence and he also accepted it, just like a trustee. Administrator is person appointed by the competent authority to administer the estate of a deceased person when there is no executor. Section 2A. Trustee is not defined in the Indian Succession Act, but the definition of Section 3 of the Indian Trust Act that applies. Trustee is the person who accepts the confidence of the testator, that is called trustee. An executor is the legal representative for all purposes of a deceased person and all the property of a testator vests in him. So this is also a very important legal proposition which we have to keep it in mind, that a legal representative is a person in law who represents the estate of the deceased and includes any person who interprets with the estate of a deceased. And where any party is sued in a representative character, the person on whom the estate devolves on the death of the party so suing or sued. This is having a wider impact on wills. When the disputes arise and the estate has to be represented, who has to represent the estate? It's only the executor. That is the importance of an executor. When two sets of natural legal heirs fight for the bounty that is left over, I mean, that what the testator has left behind, then the estate has to be represented by somebody. That is the role of an executor. So he is the legal representative. His natural legal heirs are not the legal representatives. They are only onlookers until the competent court decides who is the legatee. That is the beauty of testamentary dispositions, the effect of this. Then we come to legacies. Three types of legacies: general legacy, specific legacy, and demonstrative legacy. General legacy is if a legacy is given in general terms without specifying the time when it is to be paid, it is general legacy. The legatee has a vested interest from the day of the death of the testator. If he dies without having received it, it shall pass to his representatives. Then specific legacy is defined under section 150. Where specific property is given to the legatee, the legacy is specific. I may explain it right now. If a fund is provided, or a fund to be constituted from the estates, and somebody has to be maintained out of it, it's a specific legacy which may not lapse out of it, because that is a fund that can be kept or earmarked for the benefit of somebody else. That is specific legacy. Then demonstrative legacy. Where the legacy is directed to be paid out of a specific property, it is demonstrative. Demonstrative legacy, once again I will explain with the help of section 150. The testator bequeaths a certain sum of money or a certain quantity of any other commodity and refers to a particular fund or stock as to constitute the primary fund stock out of which payment is to be made, the legacy is to be demonstrated. The lapse of legacy. This is a very important part of the. Am I audible? Am I audible?
Yes, yes.
Yes, very much.
If the legatee does not survive the testator, the legacy cannot take effect, but shall lapse and form part of the testator's property, unless it appears by will that the testator intended that it should go to some other. Here, I may invite my viewers' attention to the illustrations to section 105. Normally, the illustrations are just to explain what is there in the substantive part of the section.
Some distractions.
But section 105, there you may kindly go through the illustrations. The illustrations set out rules. That's a very, 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 very interesting aspect as far as section 105 is concerned. If a legatee does not survive the testator, the legacy cannot take effect, but shall lapse and form part of the residue of the testator's property, unless it appears by the will that the testator intended that it should go to some other person. Of course, all litigations are to the effect when there is any doubt as to whether a legacy would survive after the death of a legatee. Who would be the next legatee, or who would succeed to the estate? It's a difficult question. Section 105 may appear to be so simple, but it is not so. There, the illustrations are to be looked into, because illustrations set out rules, not just illustrations. Let us see. For academic interest, let us examine. The testator bequeaths to B rupees 500 towards which B owes me. B dies before the testator. The legacy lapses. That's the first illustration. Second illustration, the bequest is made to A and his children. A dies before the testator or happens to be dead when the will is made. The legacy to A and his children lapses. 3. A legacy is given to A, and in case of his dying before the testator to B, A dies before the testator, the legacy goes to B. 4. A sum of money bequeathed to A for life, and after his death to B, A dies in the lifetime of the testator. B surveys the testator. The bequest to B takes effect. 5. A sum of money is bequeathed to A on his completing his 18th year, and in case he should die before he completes his 18th year, to B. A completes his 18th year and dies in the lifetime of the testator. The legacy to A lapses, and the bequest to B does not take. Then 6. The testator and the legatee perish in the same shipwreck. There is no evidence to show which died first, the legacy. So, very beautifully it is illustrated. The rules are set out in the illustration, not just in the sections. Then I may conclude, but I may add something before my conclusion, because conclusion that I may be permitted to point out something. Please bear with me. A will carries with it the soul of the testator. His subjectivity has to be gathered from the words and expressions in the will, which are his aspirations. Courts adopt an empathetic approach in analyzing wills, obviously keeping in mind the fact that it is a solemn duty to give effect to a dead man's wish. Now, let us examine whether the courts are treating wills, whether in the principle, in a principle that has been accepted by common law, that the testamentary freedom and testamentary subjectivity are to be honored. It is not so. Many of the decisions which I came across, you might have come across a lot of decisions that some courts would say that testamentary capacity and the subjectivity are to be decided by a court in good conscience, because it is a solemn duty. That solemn duty of a court has to be duly performed. It cannot be on rigid technical terms. Of course, I'm not pointing out that it should be done without proper proof. No, absolutely not. A ruling of our Honorable High Court, K.P. Leela Menon versus K.P. Rajagopala Menon by Justice Mr. Bhavdas. There is an indication of this. It is reported in Manu K.E. 245 of 2011. You kindly refer to it. It is well settled that the determination of the genuineness of the will is not a matter confined to the parties. Law is clear on the point. Once the will is brought to the court, it ceases to be a list between the parties and it becomes an issue between the propounder and the court. Beautifully it is. It becomes a list between the parties. No, it becomes an issue between the propounder and the court. Such proceedings have an element of solemnity. His Lordship has correctly explained it. I may draw your attention to a ruling of the Bombay High Court, AR 1914 and Bombay 266.
Justice Chagla. MC Chagla.
AR 1914 Bombay 266.
Yes. Justice MC Chagla.
Vishnu Ramakrishna versus Nathu Vittal and others.
What's the page number?
AR 1914 and Bombay 266.
Yes.
We are dealing with the case of a will and we must approach the problem as a court of conscience.
Okay, good.
It is for us to be satisfied whether the document put forward is the last will or a testament of the testators. If we find that the wishes of the testators are likely to be defeated or thwarted merely by reason of want of some technicality, we as a court of conscience would not permit such a thing to happen. Of course, that is the spirit of conscience of a court.
Is it not Justice MC Chagla?
Exactly. Thus, it could be seen, because the words speak for it. Thus, it could be seen that the courts, while dealing with testamentary cases, act as a court of conscience. Such cases are not to be being considered as ordinary litigations. There can never be abject proof for the state of mind of a testator. Of course, I may once again point out under section 3.2, it's a fact, it's a mental condition of which a person is conscious or not. There can never be abject proof for that. But the circumstances may speak for it. A legal practitioner should also understand a will is not like any other document of transfer. Because what I may say is that we owe a duty to our client. When we are drafting a will, we should give effect to the wishes and aspirations of a testator. It should be gathered first hand, right from the horse's mouth, not from a third party. Never ever entertain a third party while drafting a will, because a third party may not be the right person to give a lawyer the instructions to draft a will. It has to be made a point of prudence, a caution, and also, of course, a part of ethics for a lawyer, that one shall not adhere to the instructions of a third party. Of course, also the same, that when attesting witnesses are being selected. They shall not be paid attesters. Many of the wills fail in court just because that paid attesters used to attest it. There, it is very clear that the paid attesters are having no animus attestant. They are just doing it for some consideration. That consideration might have been paid by somebody else who may be able to pay on the will. So an attesting witness should be a credible witness. What he witnesses is the solemn act of the testator executing a will. He is having in his mind that his wishes and aspirations should be given effect to at my time. That is that man's wish. If we are not giving justice to that man's wish, we are not doing any professional service, or even courts are not rightly interpreting the testamentary capacity or testamentary freedom of a testator. Of course, everybody would be erratic. Nobody is infallible. But still, when we go to the rules of testamentary law as set out in the Indian Succession Act, the various sections, the illustrations, everything to be read as a whole, we will find that Indian Succession Act is a complete code of testamentary succession. With all these principles, it underlies, all these principles underlie these 11 provisions. That's what is my attempt to establish. So I may once again say that testamentary freedom, testamentary capacity. So there it requires a paradigm for judicial review of wills. That is, it shall not be rigid technicality. And some decisions for the academic interest, I may point out. A recent ruling of our apex court, which may kindly be taken note of, AR 2019 Supreme Court 5682, or that is in 2019 KC 5523. There is no express presumption in the statute that the testator must necessarily sign the will in the presence of the attesting witness only, or that the two attesting witnesses must put their signatures on the will simultaneously at the same time in the presence of each testator. Attesting witnesses deposing that the testator came to them individually with his own signed will and read it out to them, and read it out to them, after which they attested it. Their attestation is proper. This is the case what happened. Justice that pointed out last time. In Uma Devi's case, that is what happened. That is a very respectable attesting witness. He attested it only later. On the facts of the case, we will find it. So this is also a paradigm shift that the apex court in a recent ruling accepted that, because attestation need not be in the rigid form. Even mutuality of witnessing is also not a proper way or a method for proving will or attestation. And there are some rulings which I can point out later at the time of interaction. So thank you all, my dear viewers, my respected panel members. Thanks.
In fact, it was indeed wonderful. Moderator, can you just stop the screen?
No, I will stop. I will stop it. I will stop it. Technical difficulties to stop.
No, absolutely no difficulty. It's a wonderful scenario.
No, kindly bear with me for a moment. I am just trying to see how it works.
We would like to have a good dip.
Just 1 second, please. these technical things. Oh, stop share. Okay, thank you.
Wonderful. Justice Shashidhar Nambiar sir, can we come back to you again? It was a wonderful exposition by Advocate P.T.Mohankumar
Yes,
sir.
definitely.
Your comments on that. We'll go for the interactive session later on, sir. We'd like to have your take on that.
Mr. Mohankumar has elaborately dealt with the subject in deep. Subject. Lot of pain has been taken.
Thank you, sir. Thank you, sir.
The result is a very good performance. Thank you, Mr. Mohankumar.
Thank you, sir. Thanks. Now it's my privilege that you moderated. Right from my younger days, I was seeing you.
Yes.
Ramkumar sir.
Done complete justice to the law of wills.
Wonderful. Kamal Pasha sir.
Beautifully done. Beautifully done. Because no words. She has done the job in an excellent manner.
Encomiums apart, let us get
Thank
out
you.
of this.
Mr. Shyampadmanassociates,
Yes, sir.
regarding the question posed by us earlier,
Yeah, I'm coming to that, sir. I'm coming to that, sir.
I feel that we will have to go by the principles contained in section 119, which he has not dealt with it. And that will take effect only on the death of the other person also.
Sir, I'll frame the question in a different manner. Mohankumar sir, if I may
Yes,
put
of course.
to the eminent panel, like.
Mohankumar, you go through it 119. I feel that that will give the answer.
I'm ready with that.
Postponement.
Fine, fine.
Postponement.
The equation or the question is very simple. That is, I got a right to bequeath.
Okay.
I got a right to chart out the manner in which my property should go after my death.
Right.
If it conflicts with any of the existing laws of the land, first question, I'll come to the second thing. How does it go? For example, rule against perpetuality, or what you call
Perpetuity.
perpetuity. I'm sorry, sir. Perpetuity. Okay, I say that my property can only be handled by 1, 2, 3, 4, 5 generations thereafter.
That's
That's my will and volition to write a will.
okay.
My will is there. How does it come into effect as long as it conflicts with the other provisions of law? Number one. I'll come to number two later on.
Is not Justice Chidambaram here?
He was there. He just left, I think. 1 second.
Section 119. You go through section 119. We will get the
Postponement.
principles section. I wanted to have a discussion. That's why I did not mention it earlier. Section.
Tell me,
I
sir.
feel the principle is contained in section 119. If another
No.
the bequest can be postponed. The bequest need not take effect of that itself. It can be postponed. It can be postponed. That's what section 119 says. When there is another event has to take place for the bequest to take effect, it will take effect only on the happening of that event.
How far I can stretch that?
See, that's what it is for. It is for the legal heirs. Till then, the legal heirs can handle the property, intermeddle with the property. Therefore, it is their bounden duty to preserve the life of the other man, so that they can enjoy the property. That's what the section 119, the principle.
Kamal Pasha sir, my doubt is something different.
Okay.
It can be deferred to another date. It can be deferred to something else. But if it comes in direct conflict with another proposition of law,
Right.
Go.
Of course, then it may not take effect, because if it is in conflict with any provision, suppose perpetuity, etc., if that is the case, of course, that's some other thing, because it cannot have a conflict with the other provisions, the other laws of the land.
Then what happens to the intention of the testator?
Pardon?
That's it.
Then what happens to the intention of the testator?
Intention the testator in this case is that his bequest will take effect only on the happening of another event. Then that is his intention. So that only on the happening of that other event, the bequest will take effect. Suppose. it conflicts with any other law, of course, the legacy will be will not be valid.
Sir, I mean, am I to take that the testator should be conscious of the legal provisions and the legal mandate before writing a will?
Of course, otherwise it may act against his interest.
Sir, if there is no bar under law to give X, Y, or Z way,
Right.
one among which I choose,
Okay.
can I be condemned for that?
See, he can choose it, and he can give his property to any person according to his will and pleasure. Of course, he can do it. He can execute a will. He can make a bequest. But if that violates any law, of course, we need not that there need not be any further answer for that. If it violates any law, of course, that bequest will not be valid. But see, when the bequest has to take place on the happening of some other event, that if that is his intention, that will take effect. The bequest will take effect only on the happening of that event.
Sir, what I'll do is that before opening up for our open forum, I'll just confine my question to a finer point.
Right.
Fine. Rule against perpetuity. Fine.
Okay.
That he is hit. And
A for life, then B for life, then C for life.
Correct. To that extent, it is hit. But I have indicated my preference of the way in which it has to go. So how do you weigh these two together? Perpetuity, of course, fine. You cannot say that it cannot be tied on like forever.
Right.
But I have said that it ought to go in my male or female or now we got a third gender also.
Okay.
Third gender way it has to go. So
it's possible. That can, because suppose in order to take the if the legatee dies, predeceased testator, normally the legacy won't take effect unless the testator says that I am giving the property to my daughter so and so, and also to her children. See, if that is there, the legacy in favor of the daughter alone will not take effect, but the other bequest will take effect. But if it is in perpetuity, of course, no, nothing can be done.
Perpetuity as such may stand in the way, but according to you, other things can happen. Ramkumar sir, your take on that?
But on what?
Sir, the question is very simple. The example I cited, there is a problem because it hits the principle of perpetuity in the sense like you cannot tie down the property forever. But I have indicated my intention of how it has to go. Forget about 10th generation or 12th generation taking it. Can that be overridden, saying that the entire my intention is entirely gone because
to the extent possible, the testator's intention has to be given effect to, and it should not be frustrated. That is what Justice Chagla also held in 49. The court, as a court of conscience, the court will not allow the intention of the testator to be frustrated. Every endeavor will be made to see that every clause in the will is given effect to, is made legitimate.
Such extent as possible without having any friction with the existing law.
Yeah, exactly.
Shall I intervene?
Yes.
Okay. Shyam.
Sure.
Section 114 of the Succession Act. You may please go through that. If you want to make a provision in the form of a bequest to some person who is not yet born,
Unborn,
or somebody is not in existence, you cannot do. The law imposes a restriction which is contained in section 114 that you can postpone. You can postpone it only up to the lifetime of one person. You have to create an estate in favor of some person during his lifetime. Then, of course, it can be such that thereafter it will go to another person who is yet to be born. It's very clear. You asked about some questions against some laws. It is very clear under the Indian Succession Act. I have come across 3 conditions. 1, a will cannot be executed for immoral purpose. That is against the public policy. It cannot be done. Second is also based on public policy, section 114, just now I explained, rule of perpetuity. Third, it is a sum and substance of all the testamentary rules. It shall not be ambiguous. Ambiguity kills the will. These are the 3 conditions set out in the Succession Act, subject to correction.
Sir, our query, I mean, forget about me. Our query is that what is then the role of the testator or his intention to have the property devolved in a particular fashion or a manner? Interdict of law to what extent?
Interdict of law is that, very simple, it shall not be ambiguous.
Should not be to non-existent persons.
Ambiguous. Ambiguity shall not be there. Of course, ambiguity may arise. The court can clear it. That is why I refer to extraneous circumstances. Extraneous evidence. Actually, I'm sorry. Extrinsic evidence.
Intrinsic evidence.
Extrinsic evidence is the circumstances under which the will was executed. That circumstance can be ascertained by a court to clear the ambiguity. So ambiguity is one aspect. Second aspect.
All to effectuate the intention of the testator.
How the intention of the testator has to be effectuated? The armchair rule, the presumption rule, and every rule that has been set out is what was the intention of the testator. That is to be looked into. Plain meaning of the words. And we had a discussion about
the testator may be a stupid guy. He may say, he may not know the law. He may say something entirely different. Then how to reconcile that?
Only if it is reconcilable.
Because
the
reason is that every person is presumed to be sane, so that every person is presumed to know law.
Maybe I'm an exception.
See, a person, an innocent testator, a man who is not conversant with the laws, he may get legal assistance. It is the duty of a lawyer or a scribe, if he is professionally qualified to do so. He has to advise him how it has to be done. That is why I point out in my talk that he owes a duty. He has to get the intention of the testator. He has to note down, and it's a practice that it should be read out to him. It has to be acknowledged. He has to approve it. Then it has to be written as a will. That is in practice that what has to be done.
So I'll come back to you. For the time being, can I request Advocate K.R. Pradeep, who has raised the hand? Please put the question. Pradeep.
So first of all, it's a very informative class. My doubt is regarding when an ambiguity comes, how it has to be cleared. When I am a lower court lawyer, one common scenario we face that when registered or unregistered will, when we reach the village office for the mutation purpose, normally in case of unregistered will, they will reject it on so many grounds. Sometimes it may be an ambiguity. There is an ambiguity in survey number. Survey number is different, and there is an objection from the other person's legal heirs. So, and there is no suit also. How the ambiguity has to be created? There is no. It need not be probated. There is no suit. Nobody has challenged the will. But when I reach the village office, the other legal heirs objected because I am objecting that will. So when my question is two-part: how the ambiguity is cleared. Then, when a will is presented, village officer has not ready to remit the tax, not ready for mutation in my name. What is my remedy?
In an unregistered will is as good as a registered will. In a layman's concept about a will is that will, if it is registered, it is having more authenticity. Absolutely incorrect. In your case, the ambiguity will be there, of course, if survey number is not mentioned, it is not an ambiguity. If the property of the testator is identifiable, if the property of the testator is identifiable
Right.
with reference to the descriptions in a document of title, and if the testator is referred to my dash property which is having a name, or if he says that my property under that document, or there will be some reference. So you may go through section 80 and 81 of the Indian Succession Act. 80 and 81 of the Indian Succession Act gives a complete answer. If it is unambiguous, then no problem, it can be given effect to. But when there is ambiguity, under section 81 it is clear. When there is an ambiguity or deficiency on the face of a will, no extrinsic evidence as to the intention of the testator shall be admitted. So that ambiguity which goes to the root of it, when there is no property or if the property is identified by the description, the will goes. But if the will is one where some description of the property is given, then of course, then extrinsic evidence, that is the document of title or some other document, or if there is any reference to another document by the principle of incorporation by reference, it can be looked into.
But Mr. Mohankumar, his doubt is when the village officer refuses to effect mutation, what is his remedy?
If he refuses to effect mutation, what he is doing is an illegal act because he has to do it.
All right, but then if he refuses, because
but
either on account of the objection by the disinherited heirs, or on account of some ambiguity in the document.
Whether I have to can file OP before High Court?
I will explain. If the mutation is refused, under the mutation rules, the remedies are provided. Appeal can be preferred. There are other provisions which
PV appeal.
This appeal can be preferred, and that also goes against your client. A writ can be filed.
You can go to Lokayukta also.
Lokayukta also. There are several remedies.
Inaction or malice in action.
Above all, it should not be one covering under section 81. It should be one coming under section 80. That is the ambiguity is level, which is possible to be cleared. That is
it. Am I audible? Yeah, fine. We have.
What about the earlier doubt, Mr. Shyam?
Sir,
joint will.
even for the time being, can I just put that again?
Joint will. I may be permitted.
When you gave the screen sharing, the description of joint will was both of them desire the will to come into force after the lifetime of both. That was the screen sharing.
I will give a citation. AR 2017 Supreme Court 1473. AR 2017 Supreme Court 1473.
Yes.
It's a case where the apex court has explained it. I will just read the relevant provisions. That is, the above question would depend on the construction of joint will. Did it create any mutuality among the executants of the joint will? That is the question to be answered. Did it create any mutuality among the executants of the joint will? Because a joint will cannot be confused with a mutual will.
That is only for mutual will, yes.
Whether so and so, having accepted and after his wife's death, was competent to do anything contrary to the ultimate because. I am skipping it over. Then I am coming to that. After the death of the first one, without revoking his or her own will, makes the joint will irrevocable by the survivor. But there must be an agreement that the wills would not be revoked after the death of one of the executants, or disposition will not be made contrary to the will after the death of one of the executants. Such an agreement may appear from the will or may be proved outside the will, but that is not established by mere fact that wills are identical terms. If such agreement is shown, each party remains bound. I may explain it. See, the mutuality clause would be there, either me or you, if it is there. If one dies, the other survives, he continues to enjoy the property. And if there is a provision in the will, either you or me, or if both of us are not there, or if you are not there, or if I am not there, so and so. This should be the provision to be made in a mutual will. A joint will is that the separate wills, separate and distinct properties. It cannot be confused with mutual wills. The mutuality should be there. Mutuality means there should be an agreement in the will.
Mutual will, they are reciprocal testators and legatees. Reciprocal testators and legatees.
Joint will is nothing. Joint will under law that can be
joint will in respect of a joint property.
Joint properties.
What should happen if there is a clause that this shall take effect only after the lifetime of both of us?
Oh, exactly. It cannot be confused with mutual will. So
when does the will take effect? Will it take effect on the death of one?
That also we cannot say that without we cannot visualize a given situation unless a given case is there, because a will has to be interpreted with reference to recitals. In the recital, as I point out with reference to this ruling, that if there is mutuality and if there is an agreement binding both testators, then that will prevail. So that depends on the interpretation of a recital. It is not so easy to say in an imaginary situation. That is what I am pointing out. Because in a will, we can only give an opinion after analyzing the recitals only.
Mohankumar sir, can I just shorn off all these technicalities, everything? Me and Sri.Shyam Nambiar sir executes a will.
Yes.
In respect of which properties? What are the properties?
Properties are entirely different.
Jointly owned or separately owned?
Sir?
Is it jointly owned or separately owned?
Absolutely not. Absolutely not.
Separately owned.
Separately owned, and there is no way this.
Then there is no problem. Then there is no problem.
Sir, that's why. Let us analyze the first equation first. Then we'll come to mutuality. So, my property is in Calicut. Sir's property is in Talasheri, Kannur, wherever it is. Kasaragod for that matter. Wherever it is. And we say that this will shall come into effect only upon death of both the parties.
Let me answer. See, two or more persons agree to make it. Is it right?
Only two.
Only two. The clause is that to take effect after the death of both persons or after the death of one person.
No, two persons. Both.
If it is to take effect after the death of both persons, it will become effective after the death of the last person.
Okay, I die tomorrow. Then what about the interregnum period for the next 50 years? That
is what I am pointing out. The provision should be there in the will that what would happen if A dies and B survives. If A dies, what would happen to his estate? Provision should be there in the joint will. Otherwise,
if not.
The passage which you read from 2017 is whether one of the testators has given the power of revocation to the other surviving testator. How can that be? When one of them dies and his separate properties have been dealt with under the will. Absolutely. How can the surviving testator revoke this will with regard to the dead person? He can't.
Exactly. Cannot be done.
He cannot revoke the will of the other man.
Another
Then,
person who is
then what
he-
happens? This cannot be in an animated suspension.
Well, again,
can there be a vesting, postponement of vesting?
no, I can point out. See, the principle is that I can explain it. That is, that will go to the wording used is that will go to the residue of the testator. That's how say wording used. That will go to the residue of the testator.
So the,
That is-
so the bequest lapse.
Ah,
So the
revert
bequest lapse.
Legacy lapses.
exactly. That,
If
revert back to
legacy
the-
lapses, then that's an end to my, our entire query. The simple equation is that the wish and the volition of the testator is having no significance, right?
no, as
There's a
far as
big-
that property is concerned, as far as that property of
No, every property is
Legacy
concerned.
cannot lapse.
That means
Cannot
that's the only
lapse.
property he has.
yeah, the point is only this:
How can it lapse?
A and B
It
are
won't lapse.
No, no.
A
It
and
won't
B
lapse.
And
It shouldn't.
it cannot lapse, according to me.
Lapse ചെയ്യത്തില്ല. No, no. It
No,
won't
it
lapse.
won't
I
lapse.
can explain. And then let me explain. A and B, Shyamanta question. A and B are executing joint wills.
Yes.
Use of joint wills by two or more persons. That is having not the effect of a mutual will, unless it is having the effect of a mutual will.
All right. It is joint will.
And a joint will, it operates according to the recital. If the recital is that after A, what should happen? There should be a recital there.
No, just imagine there is no recital. Why should you say there should be a recital? It's my volition to write what I want in the will.
Then
I
it is-
write that this will shall take effect only upon the death of both of us. It so happened that the first person dies, the second person dies only after 25 or 30 years. So what do you do?
Because joint will,
No, you forget about the nomenclature of the will, joint or whatever it is.
Can
Two
the
persons
vesting-
have written that.
Can the
Then
vesting
Vesting can be
postponed?
postponed.
Yeah, that's
Can it be
postponed?
the only question. That's the only question.
vesting will not be postponed because there is no
Why?
provision in the will.
Why? There is a provision in the will.
No, some the bequest should go to somebody else. It should be provided the will.
No, I'm not
There
providing
is.
what
There
happened.
is. It is provided. It is provided. But the vesting is postponed.
Correct.
There will be a vesting.
No,
That is postponed till the death of the survivor also.
I'm sorry. It may be my mistake in understanding it. Let me ask, Mike. See, A and B. The question is, A dies. What is there in the joint will as far as A's estate is concerned? എന്താണ് provision?
That again will depend on the nature of property. If it is their self-acquired separate properties,
Exactly.
then on the death of A, his property should devolve ordinarily. But what is the effect of a clause in the will deed, or rather a subsequent clause in the will deed, which specifically says, this will shall take effect only on the death of both of us.
Absolutely.
If both are having rights over the property jointly.
No, why should there be a right over the property? I make an interdict saying that including my property or his property, this whatever is written here will take effect only upon death of both of us.
The vesting is postponed till the death of both.
Vesting is postponed.
Can it be done? First of all,
That's a preliminary question.
See, that is the question because, as far as this clause is concerned, my view is that I can explain, I will explain with reference to case laws also.
Yes.
That as far as the legacy of A is concerned, it lapses because it cannot be put indefinitely.
how can it lapse?
Because there is no provision for vesting.
There is a provision for vesting. Only thing is postponed.
To whom it has to be vested?
There is a specific legatee.
No, sir.
There is a specific legatee.
My doubt is only this: whether it is provided that A's estate should vest with somebody.
Yes.
Yes. Legatee is there. There is a legatee.
To
There is a
whom?
named legatee is there.
Deferred. It is being deferred further point of time.
Okay, if a named legatee is there,
Yes.
if a named legatee is there, it is just like saying that it will vest after a time.
Correct.
That is precisely the question. Whether that vesting can be postponed
That
till
can
the
be
death of the last the
that
survivor.
can be postponed, but it shall not be beyond the lifetime of one person. Okay.
Sir, can you just clarify that? I mean, that's what exactly the question is. to what extent we can postpone?
That can be postponed till the happening of an event. Contingency, if it is provided. A contingency should be provided.
That contingency is this. Until
Contingency
both of us,
also should take.
die. Until
Yes.
both of us die, the
So that
will
means,
not take effect.
that means that until the other person B dies,
Survivor.
survivor, he is a
Correct.
survivor, then only the legatee will get it. Very
Sir,
clear.
so that clause is valid according to you.
That is valid. That is
Okay.
valid.
Then what happens during the interregnum period?
During the interregnum
The
period,
estate has to vest or somebody has to handle that property.
During
See, I die today.
during the interregnum period, there should be provision in the will.
No, I
There
have
is-
not made. How do you say? You cannot dictate that I should make a provision. I have not made any provision.
Normally, there will be provision. If there
No,
is
no provision.
if there is no provision, the person who survives, because that B, whether B can intermeddle with the property, if there is any provision like that.
No, nothing. B is having Shashidan Nambiar sirku Kannur Kasaragod allathu, Erikku Kozhikode allathu. No way either of us can intermeddle with the property. Vanna adi kittum. Nadakkilla. The only issue is that if that be the case, what happens? I die today, sir, oru 20 years കഴിഞ്ഞിട്ടാണ് വിചാരിക്കുക. Then 20 years, who is going to handle or manage my property? There is no executor, there is no nothing. I not mentioned anybody in my will.
And nothing will
That's all
postpone.
I doubt.
Then I have to,
Postpone
then I-
legal.
it's an anomalous position, then I have to study that and I can
Please.
give an opinion.
Yes. All right.
No, no.
You are
just,
free.
one-
You are free to make
Anish,
it.
Anish, you got a doubt? Please, Anish, come forward.
Hello, good evening, sir. So I have a doubt. So A is a Hindu wife, and she has a left out. She has a minor son, and her husband deserted her a while ago. And the problem is that she was not in a position to make execute a registered will. But what she did was she sent a registered letter to the registrar office mentioning that all her property shall be dissolved to her minor son after her death, and she passed away. So whether such a letter can be assumed as a valid legal declaration?
No, it is not a will. It does not satisfy the test of section 63.
Characteristics of a will. Okay.
Yes. It does not satisfy the test of in section 63. Am I right, sir? Professor?
Right.
Absolutely right.
Section 63 has to be complied with.
The requirements of a valid will should be there.
Okay, sir.
Sir,
Thank you.
sir,
Yeah, Pradeep, please.
sir, one dot, sir. A person dies and he write. Hello.
Yeah,
Hello.
Please.
A person dies and he writes his intention of devolution of
After death.
how it should be in a piece of paper and keeps it in the locker. And after his death, children comes out, opens this locker and comes out with the letter. And whether that can be treated as a will or how it should be the status.
Same as the earlier question, earlier answer.
Okay.
Sanjay Shah. Sanjay, please.
Raining cats and dogs.
Sanjay Shah, please.
Hello.
Sanjay, are you there? Yeah, please.
Yeah, sir, I was thinking about your discussion we were having about joint will. You know, A and B people, and finally, condition is there that based on A dying, it will continue till B is there. So I was just thinking, can't B be the trustee of that A's property? I was just thinking, is it right?
Not so appointed.
Unless so appointed, how do you say that?
Morally.
No, because you have put a condition. A and B has made a joint will, made a condition saying that the will take effect only after A and B both die. Then what should be done? Because it cannot be lapse. What you are saying is correct. The discussion is correct. So what happens to the property in the meanwhile?
legatees cannot take the property till the death of the survivor.
Right.
So then what? So then it is not an injustice to the legatees. What I am saying is because there a ridiculous condition has been imposed.
Where is
saying
the
it will
question of
take effect.
injustice to legatee? This is testator's property, their property. They can do it
No,
according to their sweet will and pleasure.
no, that is fine. Then the testator's intentions will not come into effect. No, finally.
Their intention has to come into effect. That is what Justice Chagla said in 49 Bombay. Every endeavor should be made by the court to effectuate the intention of the testator. And court should not allow a will to get lapsed or get invalidated. Every endeavor
correct.
should be. So here is a testamentary instrument which says that this instrument shall come into effect only on the death of both of us.
Yeah, like many a times you will observe that wife and a husband, nobody knows who will die first, and they have a joint property, most of the time. So then how do
And
they go about making a...
They may even fall apart after the execution of the will. They may become even worse enemies.
Yeah, they can be divorced also. I mean, I agree with you what you are saying. But I'm just saying, that way the will can be rectified. But what I'm saying otherwise, how does it come into effect? I mean, a husband and a wife making a will,
Anyway, we will expect the answer from Mr. Mohankumar after he makes a further research.
Yes, I will.
Okay, fine. Yeah, please, because put it in the group. I will be thankful if that.
Definitely, Sanjay. Sanjay, we'll address that. I mean, that's the beauty of our what do you call journey. Every time a new question or a new proposition pops up, we'll think about it and we'll definitely answer. I mean, we are not coffee vending machines, right? You put something on top and you get coffee underneath. It's not possible.
Yeah. No, that's not law. Law is open to interpretation.
Absolutely, Sanjay.
I agree.
And Suresh, you got a question? Suresh P. Abraj NK.
Sir, good evening, sir.
Yeah.
Good evening, Babraj.
Yeah, please.
Sir, my question is that a registered will, it is 30 years old. Whether it is come under the provisions of presumption under section 90 of Indian Evidence Act, without examining the witness under section 68 of the Indian Evidence Act.
Bhavra sir, you have put a very pertinent question, which has been, I mean, in this forum, it is being debated like anything. Section 68 vis-a-vis 90. The earlier we were discussing that 68, thereafter 90 came in, so 90 has to outweigh 68, etc. But whether it is 30 years or otherwise, can you dispense with the essential prerequisites of 68 in proving a bill just because it's 30 plus? Moderator, or two.
So the question is, because this was discussed, as Shyam has pointed out, that is whether the necessity for examining an attested witness can be dispensed. Is that the question?
Yes.
Essential prerequisites of 68 can be dispensed with just because it's 30 years old.
See, that is a debatable point, because the section 90, we were discussing it last time, because section 90 deals with a case where a court may presume. May presume is not shall presume. It can be interpreted otherwise. May presume means the court can. Suppose if it comes from a proper custody, and if it is not disputed, and if there is authenticity attached to that will, of course, court can take a presumption that the will is valid. That there are so many rulings. If you want, I can furnish those rulings also. And we have discussed it all. Now, if it is a question of interpretation, whether section 68 and 90 are considered together, whether section 90 would overlap section 60 or eclipse section 68 is the question. It will not, that is one branch of, or rather, one set of opinion is that it will not. Another set of opinion is that it can. And there are so many rulings, even the Honorable Apex Court is also in confusion as to what is the right course to be taken, which has to be accepted. Even the latest ruling of our Honorable High Court also will furnish the rulings also in the group. There, Justice Hariprasad has pointed out that in a case where will is not disputed, it was on proper custody, then it can be accepted without examining and attesting one of the attesting witnesses. So that is a debatable point.
Mohankumar sir, I mean, as of now, the preponderance of the decisions, is it in favor of dispensing 68 vis-a-vis 90 or otherwise?
No, I can just point out, because last time I concluded by saying that there are rulings of Punjab and Patna High Court. Then I refer to that also. I will give it in writing, that, because that was during the last session. What is the point, a reasonable point that can be considered in the matter of interpretation is that if it comes from a proper custody, if does not give rise to any suspicion, if the will is not shrouded with any suspicion, it is not shrouded with any suspicion, and the words are not ambiguous, and if it satisfies other tests, and coupled with that, it is 30 years of old, and also there is registration. Proper registration is also there. There the registration gives some authenticity or additionally. Then of course, it's a case where it can be considered. That's a Privy Council view also we discussed earlier. We will furnish all the details in the group.
We'll come to that, sir. Of course, that's reading something into the provision, because 68 or 90 does not say anything about shrouded with suspicious circumstances or anything. It only says about the technicality of proving, etc. We'll come to that, sir. Before that, can I have Advocate Pramod Mancheri, please? Pramod, can you unmute? Please unmute yourself. Yeah.
Can you hear me? Yeah, I'll just leave from the very same question, but on a different tone, because you were referring to joint wills. I'm not on joint wills. It's an individual will. An individual will, whereupon the husband says the property will be bequeathed in favor of the wife, daughter, only after the death of the wife. So the daughter can enjoy the property only after the death of the wife.
Life estate to the wife.
No, can it be?
Correct.
Yeah, because the bequest is in favor of the daughter, but the version or the statement of the will, it's the effect that it will take effect only after the death of the wife. The difficulty arises because the wife being under the Hindu Succession Act, the wife being a class 1 heir, succession opens the very moment her husband dies. So her right is being infringed. The husband does not say that this has disinherited the wife. I hope you can hear me.
Pramod sir, there is one.
Wife is not a legatee.
No. When you say something that somebody should take my property, why should I say that other persons are excluded? It's automatically excluded.
No, the difficulty is that you see, immediately on the death of the husband, the wife automatically succeeds to the heir.
No,
the will is only an exception, or the will is only.
If he dies intestate.
Yes,
if he dies intestate.
Yeah. No, what I'm saying, sir, what I'm saying is, suppose the wording is to this effect: the daughter will get this property after the death of the wife. Now, yes, if that clause, because actually it is just as your Honor was pointing out, it is actually postponing enjoyment. The death of the wife.
Yes. Life interest is for the wife. What is wrong with it? It can.
Also, there is an interim. No, until the wife dies, what happens to the property?
See, wife has to enjoy the property. He has got the life interest.
She can maintain the property. She can enjoy the use of rights.
Can she enjoy the property as of the husband?
But she cannot dispose of the property. She cannot put an end to the corpus. She can enjoy the usufruct. She can enjoy the income.
Life estate, only that much.
The life estate.
Okay, thanks.
Again, it comes back to the same question which we had deferred to a certain extent, but we defer it to for the time being. Can I have Vishnu sir? You have put your hands up.
Yes, yes. Sir, my question is, hello, am I hearing? Hello?
Yes, yes, you are louder.
My question is one, the genuineness of the will is no doubt about it, but both attestors have denied their execution. Of course, 68 is not there. In these circumstances, what the court will do?
Who does not doubt the genuineness? Court.
Yes, yes. But actually, but attestations are gone. They are denied.
Yes.
What will be the fate of the will? Whether it is to be whether it is to be totally neglected?
Evidence Act provides for that. When the witness, attesting witnesses deny execution.
Correct. Correct.
If the denial is a false denial, of course, there are other methods. That is also there in the Indian Evidence Act. If there is a false denial of their signature, that can be proven otherwise through other methods. But it is the duty of the propounder to dispel all the substantial circumstances in the execution of the will. It is the duty of the propounder. Propounder has the duty. That's what 59 Supreme Court says. It is the duty of the propounder to dispel all the suspicious circumstances.
No, he said that the suspicious circumstances are not there.
Not there.
Court is convinced.
Okay, sir.
Yes.
Anuradha, you do have a question. Please come forward. Anuradha.
Yeah. Good evening, sir. Thank you, Shyam, sir. Mohan, sir, question for you. A has got two properties, two houses. So he wants to give these two houses to his daughter and son, respectively. But during his lifetime, he makes a will in this regard. But during his course of life, he is with a serious ailment, and one of the houses has got to be disposed of to meet his medical expenses. So, what would be the validity of the will?
At the time of his death, that property is not there. So that will, so far as it relates to that property, will not operate, cannot operate.
Yeah, but will there not be between the son and the daughter? Will there not be a?
Of course, there will be going to be a rift between them.
Yeah. So how could that be meted out?
For some family members can prevail upon them.
Okay, so the courts cannot.
Because the will being an ambulatory document, it operates only on the death of the testator. On the date of his death, what all properties are there, the will operates only with regard to those properties. Am I right, Mr. Mohankumar?
Yes, sir.
Oh.
Shyam?
Yes.
Okay, sir. Thank you.
Can you see the screen sharing?
I can only see in the screen.
Okay. Okay. This is for explaining that earlier answer. Admission by the opposite party. What is its effects?
On execution.
Yes. If the execution of the will is expressly admitted, neither Section 68 nor its proviso is attracted, obliging the propounder of the will to prove due execution of the will. That was a view expressed by the Honorable High Court, 1990 KSC 296. It can be noted. Then Prinslal versus G versus Prasanna Kumari and another, 2009 KSC 636. Then Maya Shivashankar. These were not accepted later. Then Baladandayadam and another versus Election, because at the time when Baladandayadam and another versus Election, that is 2010 5 SCC 770 was there, our Honorable High Court happened to decide based on that.
Gopalan by me.
Exactly. Yeah. Pastor sir is the author. This is a subsequent decision. Yes. Then Kerala High Court in Vadakkal Gopal versus Vadakkal Paru. They're relying on the well-celebrated decision of Venkatadele Iyengar's case, that is 1959, AR 1959 Supreme Court.
Timmajamma.
Yes, exactly. It was held that it is not possible. Then Apex Court in 2005 laid down that admission pleadings can only be about the making of the will,
not the
genuineness of the will.
Exactly.
Then same view was expressed in Gopal Siru versus Krishna Murari Mangal 2010-14 SEC 266. 62 Supreme Court 567 is yet another ruling. Kerala High Court further held in Sharda and another versus Radhamani 2017 2 KHC.
Justice Chidambaram.
Sir. Then the question is whether presumption
held that 90 Supreme Court, 90 Kerala is per incurium.
Yes. Presumption of section 90 does not apply to a will. That is the view expressed by the Apex Court in 2013-7 SEC 490 MB Ramesh versus KM Viraji hours. Then the paragraph may be, you may kindly go through the paragraph. At the same time, we cannot accept the submission on behalf of the respondents as well, that merely because the will was more than 30 years old, a presumption under section 90 of the Indian Evidence Act ought to be drawn that the document has been duly executed and attested by persons by whom it purports to have been executed and attested, as held by this court in Bharpur Singh versus Shamsher Singh, report in 2003 SEC 687. A presumption regarding documents of 30 years old does not apply to a will. A will has to be proved in terms of section 63C of the Succession Act with section 68 of the Evidence Act. At the same time, two judges bench.
Two.
Then, Mr. Prem, am I right?
Correct, two. It is all two.
Then the Privy Council decision in Munnalal and Dakuda Singh versus Kashi Bai, AR 1947 PC, whether it is misconstrued is also a question. But the relevant the portion of the judgment we can read: a party setting up a will is required to prove that the testator was of sound disposing mind when he made his will. But in the absence of any evidence as to the state of the testator's mind, proof that he had executed a will rational in character in the presence of witnesses must lead to a presumption that he was of sound mind and understood what he was about. This presumption can be justified under the express provisions of section 90, since a will cannot be said to be duly executed by a person who was not competent to execute it. And the presumption can be fortified under the more general provisions of section 114, since it is likely that a man who performs a solemn and rational act in the presence of witness is sane and understands what he is about. There was no evidence whatever that Bahadur was not in a perfectly normal state. This is AR 1947 PC 15. That is even followed by many courts. In Bharpur Singh versus Shamsher Singh, 2009, 3 SEC 687, the Apex Court held that presumption regarding documents of 30 years old cannot be applied to a will. A similar view was taken in MP Ramesh by LRs versus KM Virajavars, I just referred to earlier. Then our Honorable High Court in 2002 KLT 553, but the facts may be different. Justice Mr. Hariprasad. In this case, it is to be noted that there is absolutely no denial of execution of Exhibit A1 will. No pleading has been raised by the respondents in that regard. No evidence has been specifically adduced challenging the execution of Exhibit A1 will. It goes without saying that a fact not pleaded cannot be proved. Both the trial court and lower appellate court did not raise any issue on point regarding the genuineness of Exhibit A1 will. Admittedly, original will had been produced in this case and marked on consent as Exhibit A1. Here, our Honorable High Court held that it was a will, came into proper custody, and it was of more than 30 years old. So it is acceptable. Attested evidence need not be examined. So this is the position.
So can we take it that a will, if not challenged, need not go through the rigor of 68?
No, even there is a conflicting view of the Supreme Court.
Shyampadman sir.
Yes, Shanti.
Good evening, sir.
Yeah.
That is, if there are two attesting witnesses and the attesting witnesses not alive, both of them could not be put in the witness box. So how the will can be proved, sir?
We go to sections under the provisions of section 69. It can be proved.
Section 69.
Evidence Act provides for that.
Sir. Then another question, sir, please. There is a concept.
Shanti, 1 second.
Yes, sir.
You know the ingredients of section 69?
Yes, sir, I shall refer to. I shall refer to, sir.
69 as well as 73.
Section 69 has having two limbs.
73, 73.
Yes,
for comparison. 73 is for comparison.
Section 69 is having two limbs. First limb is that it should be proved that in the handwriting of the testator. Second, that if an attesting witness or attesting witnesses cannot be found or they are not alive, their signature has to be proved by somebody who is conversant with their signature or handwriting.
Yes, sir. Thank you, sir.
These conditions are to be proved. As Pasha sir has pointed out, section 73 has to be 73 or section 47 of the Evidence Act can be applied for proving the first part.
Yes, sir. Thank you, sir. And another, there is a concept of oral will, sir, that was not discussed. Is that concept of oral wills prevailing even now?
Oral will is prevailing for Muslims only.
Not easy to prove.
Yes, sir. So,
not for others. Am I right, sir?
Hello, privilege will. Privilege will.
Privilege will
Can be oral.
Privilege will can be oral. Oh, I am sorry. Privilege will can be oral. Privilege. Sorry. Yes. But privilege will, as you know, that it is executed by a soldier a soldier, an airman, or a seaman when they are on duty.
What about normal mortals?
For normal mortals, it is unprivileged wills.
Unprivileged will.
That has to be under section 63 only.
So for them, oral will is not possible.
No oral will for them.
Yeah, that clarifies the issue.
Except in the case of Mohammedans.
Correct. Satesha, you have a question?
Mohammedan is also one more aspect. That there are several conditions which that was dealt with. I think that in the earlier session.
Sanjay Shah, you have a question? Are you there? Yeah, Vishwan sir, you are back again. Okay. Please unmute. Please unmute. Unmute, sir.
Yes. Regarding probate, I want to ask one question. Now, in the banks and all, when they this bill is produced, they normally say we cannot accept the bill unless it is probated, even though it is not mandatory. So the question, they are doubting that because they don't know whether this bill is a last will. How to circumcise this situation?
So technically, bank is right because as we have explained it, a will, it's a very important question. A will is considered as so unstable because if a will is not possible to be proved, if a litigation comes under the set of rules, under the Indian Succession Act and also under the testamentary law, then there is an uncertainty as far as wills are concerned. So naturally, banks may insist that the will may be proved. Probate is a method by which a will can be proved. There, though it is not a full-fledged proceedings, but it is testamentary proceedings that can be explained in some other session, but I have not gone through that because testamentary proceedings itself is a very lengthy topic for discussion. But anyway, I may point out that when a probate is issued by a
probate means there should be an executor, should not? Executor. Otherwise, letters of administration.
Administration. Otherwise, letters of administration with the will annexed.
A probate is issued only if there is an executor. But under certain circumstances, a probate can be issued even.
But is it not a valid ground for the village officer also who refuses to mutate?
village officer or anybody who is
Can
doubting.
he not say that this? I don't know whether it is the last will.
Correct.
The question is that when the courts doubt about wills, then what about these public officers or banks?
When even the courts doubt.
Then public officers or banks are justified. So that probate can even be issued at a certain circumstance if there is no executor, even for a universal legatee.
If universal legatee is there, of course, probate
of
is
course.
Then letters
if not
letters of administration is a very different concept.
I think it is 222, is it not?
Citation has to be issued.
212.
Yes. Yes.
Allah,
Yes.
probate 222, I think.
222.
When there is an executor.
When there is an
only-
executor, it cannot be done by any other course. Anyway, that can be dealt with in detail in any session because it requires more
Yes,
time.
222.
Correct.
222.
222.
Probate only to appointed executor.
Probate only to an appointment.
We have Jisha with a question. Jisha, please.
Yes, sir. Sir, we have initially discussed. Hello.
Yes.
Sir, we have discussed about whether the rule against perpetuity will be applicable to the testamentary succession. I think the provisions of TP Act are not applicable to testamentary succession, and the Indian Succession Act is applicable to the testamentary succession. So that is not applicable. That Section 14 rule against perpetuity, etc., will not be applicable to the
Section 114 of the Succession Act.
Why?
Section 114. Express provision is there. 114.
Okay, sir. Okay.
Rules against perpetuity. Yes. Section 114.
Indian Succession Act.
Yes.
Yes, that is applicable.
Yes.
Right.
Not under the provisions of TP Act.
No, when
TP Act, how can it apply?
Yes.
TP Act cannot apply.
Okay, thank you, sir. Then
okay.
I want to know about the sealed will. In Malayalam, it is called Adanya will. And exact term in English, I don't know. I think it is sealed will.
Closed will.
I want.
Will by deposit.
Yes. How
Closed
to? Yes. That
at the time of registration, you can apply to be a closed will, so that it can be opened on the death with the death certificate by the legatee. It can be opened.
Yes. Before that, it should be intimated to the.
No, nobody will be aware of the contents.
I think it is the mystic will. Not.
But we have. Yes, to what person we have intended to dispossess the property have to be intimated by the person who create the same. That he can approach the forum.
What is the doubt?
The person who to whom the property dispossessed.
You mean the legatee?
Yes. Legatee.
Where he approach.
Legatee need not be the person to apply for opening the will. Any person that any of the legal heirs can approach the subject.
That person should have the okay, but that person should have the knowledge about the this creation.
Exactly.
If it is not, if suppose if it was not, nobody knows what will be the results.
Normally, every person who is executing a closed will always say to either to his wife or to the attestors or some of the persons that I have executed a will and kept it there. And on my death, you can get it opened and examine. Otherwise, there is no meaning in executing a closed will.
Yes. Okay, sir. It is clear. And one thing also. Yes. So one thing also, sir. One thing. That certificate also have to be produced.
Exactly. When if you want to get a copy of a will executed, either the closed will or an attested copy of a will, you will have to produce the death certificate, only then they will give you a copy.
Yes, to the sub-registrar office, not to the court. Yes. Okay, sir. Thank you, sir. Thank you.
Madam, I may add, I may explain it. See, if we just take down these sections, that is section 41 of the Registration Act. That is regarding registration of wills. After I'm sorry, section 42 of the Registration Act. That is regarding deposit of wills. 42. Yes. The procedure is laid down.
Okay.
43. That is the procedure on deposit wills. Then
yes.
44, withdrawal of sealed cover deposit under section 42. Section 45, proceedings on the death of depositor. These provisions would clarify.
Okay. Okay, sir. Thank you, sir. Thank you, sir. Thank you very much.
Is it not called the mystic will? Like
No,
a mystic.
Depositor will. Even an executor or some other person can also register a will after the death of the testator.
Okay, sir. Thank you, sir. Thank you very much.
Anish Kiar, please. Anish, are you there? Okay, fine. You'll have to unmute if you want to put a question. Fine. Anyway, we are getting delayed. Okay, Prem, over to you.
Yeah, Moderator, it was a very good, fantastic class. You have covered almost everything. But number one, I would like to say what Shyam had asked, whether the will can go against a settled proposition of law or a settled, a specific provision of law, which in my humble view, it cannot. See the definition of what a will is. Will is a legal declaration. That terminology legal itself connotes. It should be legal. That means it should comply with all the laws. So that particular definition of will takes in everything. Number two, when you were saying about that 90 years, section 90 for the 30 years and section 68, you had shown certain rulings and all, right? Now just see, 2014 Ramesh case was a two-judge bench decision, which relies upon Bharpur Singh versus Ramsey Singh. It's a 2009, again two-judge. Just see Bharpur Singh. Bharpur Singh is concerned again with another two-judge of 2006 Venkatamuni's case. Now see Venkatamuni's case. Venkatamuni's case never dealt with this particular aspect. Supreme Court in Bharpur Singh, it has really built up something from an imagination. Venkatamuni never said anything, never dealt with section 90. Supreme Court in Bharpur Singh went on to say Venkatamuni dealt with like this, it was like that. And this was what was taken into account in the 2014 Ramesh decision. So it has been built up without a solid foundation. First of all, a superstructure has been built up. And number two, you were showing that 47 Privy Council, page 15, Munnalal's decision, right? Now, Munnalal, that was approved by a three-judge bench of the Supreme Court in Subbaraju versus Subbaraju. Justice Shelat, 68 Supreme Court, I don't remember the page number, 900 odd, I don't remember the page number now. Now, that particular judgment is a three-judge bench decision, which was not taken note of by any of the subsequent two-judge bench decisions. When a three-judge bench was there, would you say that a two-judge bench, any number of two-judge benches, how can we say that the two-judge benches would prevail, especially when it was built upon something which was not there in the 2006 judgment? So section 90, and moreover, just see the statute itself. It admits of no, absolutely nothing is ambiguous. See 68, read 68. 68 already says not except in the case of wills, right? 68 is beautifully drafted. Now after 22 sections come to 90. 90 never excludes a will. It is a rule of presumption. It is for the convenience of the court. The court may presume. It's not a hard and fast rule. 90 can neither can 90 overstep 68, nor can 68 overstep 90. The interplay comes into effect only when it's a 30-year-old document. And just see, what does 90 say? 90 presumes execution. 90 presumes attestation. Right? See what does 68 mandate? 68, what is the purpose of calling in one of the attesting witnesses? It is only
shall
for
not be used.
proving the execution. Beg your pardon, sir?
Shall not be used. That's the wording.
Shall not be, shall not be. And what is the purpose of 68 calling the witness? Just see, it is not to prove the attestation. It is to prove the execution. And kindly see 63 of the, I mean the Succession Act. 63 merely, yeah, 63 merely would say that these are the procedural requirements which a testator has to keep in mind. Now let me just tell you just this way. Now we have a 1925 Act before us. Now we are in this room class. So I just screen share that this is my will. It's a screen share. And just like we are having some artists who used to draw, right? The testator can fix his mark. I am the testator. I say I am fixing my mark. Calling upon one or two of other persons who will be witnesses, or one person just attest it, or just put your signature that you have seen this mark. Would it become a will? Why should it not become a will? It is in writing. It bears my mark. Can't it be a will? Like on a live video, it is in writing, as I say, it is in writing. I would display and I would put my mark. I would say this is my mark in front of you all, and somebody else from us also he would attest that. Why not? Can't that be a will?
Even acknowledgement by the testator is enough.
Absolutely.
It is enough.
His signature. It is his signature.
It is enough.
Need not be, I mean, in the same presence of the same time.
Yeah, he need not sign
Absolutely.
in the presence of
Absolutely.
testator.
You know, one of the witnesses should see. Right.
That is
the other witness need not be even present.
No. That is what has happened in Umadevi Nambiar's case. But it is one witness, only one witness can we do like that, not two.
See, only one witness is required. And even in 63, you can see two or more witnesses is the word first used.
So one
then
witness
at
is
the
for
end,
proof.
it says, exactly, it is for proof.
One witness is for proof.
That the testator.
For attestation,
Correct.
two witnesses should be there.
Two witnesses.
One witness.
And see, sir, even the particular terminology attestation, section 63 requires that the attestation need not be done by the two witnesses simultaneously. Can be it's a subsequent point of time.
They need not be present. Section
itself absolutely true.
They need not be present.
In 2009, today, I think during the noon time, myself and Moderator were talking over the phone. In 2009, 2005, ever so many decisions by the Supreme Court are there saying that two attesting witnesses, they should be present at the same time. They should mutually see the other witness writing.
It is against the section. It is against section 63, against section 4 of TP Act. TP Act also attestation definition.
Answer, there is a ruling of His Lordship Justice Bhavadasan, Devasi Kutti's case, 2010 3 KLT, page number 1010, wherein His Lordship also would go on to say that you have two attesting witnesses should be present at the same time. They should see simultaneously each other signing. Am I correct, Moderator? You have you read that decision?
Devasi Kutti versus Vishalakshi Amma.
Devasi Kutti versus Joseph. Yes,
Vishalakshi Amma. Devasi Kutti versus Vishalakshi Amma, 2010 3 KLT 1010.
1010. And now I would again say one more thing. Moderator, you had referred to the 2017 ruling in the case of joint will and mutual will. 17, Palanisamy. I'm asking about Palanisamy. 2017, Palanisamy. Palanisamy was concerned exactly with a mutual will. See, Palanisamy and his wife were the testators. It was a mutual will. And there is a beautiful decision by His Lordship Justice Sasidharan Nambiar himself, 2011 4 KLJ 544. Narayani versus Sridharan. What is a joint will and what is a mutual will? The difference has been clearly that particular difference. And
for your kind information, ILR 2009 3 Kerala 221 may also be seen. That's also by his humble self.
Yes, that is the.
And there is one more clause of, one more type of will which you have not dealt with. It is called the hybrid will. Suppose a party wants to prepare a will. She first starts writing the will, partially finishes. Then she takes it out a typewriter and completes the balance in her typewriter. So it does not become a holograph will because it is only half written, partly typed. That is called a hybrid instrument, which was dealt with in an American case, Hinson versus Hinson, There's an American case, a Texas judgment is there. It's a hybrid will.
Anyway, the various types of wills were not considered, was not discussed. Various types of non-cooperative.
Yeah, he had shown
will.
that.
Yes.
No, he had shown that first. He had shown that.
Okay.
He had shown that. And anyway, it was a very beautiful class.
Prenuptial, postnuptial will, prenuptial will.
Correct.
All those
Next,
there were so many types.
There
were so many types of it. Yes.
Ruling.
Yes.
Ruling is Subaraju versus Subaraju.
Supreme Court.
1968 Supreme Court 947.
Okay. That's a three-judge decision.
That is a three-judges bench by Shaw,
Sikri and Shah. Sikri.
Yeah.
Mr. Prem, which is Justice Nambiar's ruling on mutual will?
Yes. That is
2011, Narayani versus Sridharan or Sridharan versus Narayani. Narayani versus Sridharan, 2011, 4 KLJ 544.
4 KLJ
544.
Okay.
In case of a joint will, it is revocable at any time by either of the testators during their life, or either of them after the death. And in case of a mutual will also, he goes on to say. So he has drawn a very subtle distinction also. So this 2017 judgment, in effect, it does not consider mutual will and joint will at its level.
Only in mutual will there is a reciprocity between the testator and the legate.
And last time also, sir, the theory is that the effect of postponement, that particular principle, the provision as such may not apply, but the principle of postponement can apply.
Yes.
As well as contingency, everything can apply. Because it's an armchair rule. At the end of the day, the testator's intention was to...
What else is life estate? When a life estate is given, you are vesting, postponing the vesting till the lifetime of the life estate holder.
Correct. Right. That can apply easily, it can apply.
Wonderful class. Good research.
Good.
Yes, we have done a good work, Mr. Mohankumar.
Sir, can I just put one question? Maybe an absurd question, but still. Section 90 speaks about 30-year-old documents. When does the date of a will to be reckoned for that?
When it is admitted in evidence.
Sir,
date of execution from the date of execution till the date from the date of execution till the date of admission.
Admission in evidence.
That is the
evidence,
correct.
So I execute a will today. I die after 35 years. On the next day, I get the presumption, or that will get the presumption of that 30 years.
Yes. 30 years, yes.
30 years from the date of execution.
Date of execution. Not from the date when the document takes effect and all.
Not from the date of death. That is the operation of the will.
No. I execute it on such and such date. I die after 32 years.
Yes.
The will remains. On the 32nd year, when somebody brings up the will, 90 applies.
Yes. 90 applies provided on the date of admission of the will in evidence.
In evidence.
30 years is over.
Yearly producing is not
32 years is over after my death. No. Okay, fine.
If after 32 years, then only thereafter.
No. That was a mischievous question. I do understand. Sir.
Like all your questions.
Definitely, sir. Definitely. That's why I'm here. So I would say that Jisha, okay, question has been put, and now Babu Raj. Babu Raj, do you have any question? Babu Raj, are you there?
Yeah, yes, sir.
Yeah, please.
But one doubt is there. The 30 years old document is also there. It is the registered one. Both the witnesses are died. Then section 68 cannot be applicable in such a case. Then the section 90 will be applicable.
It's a question or a statement?
No, if the execution cannot be proved by other means.
Other means. Then the section 71 of the Evidence Act is also applied. Can be applied.
Not 71, but 69.
47, 69, 47.
71 of the Evidence Act.
Even 45. But supposing there is nobody who is conversant with his writing or signature, etc.
Section 71 will be applied.
Section 71.
No, of Evidence Act.
71 is when the attesting witness comes before the court and denies. It does not apply 71.
And they also other next
Or not available, not alive.
Not,
Not
not alive also there.
Yes.
69. Okay.
71 applies only when the attesting witness denies execution.
And
denied.
also not available.
Other one is
And also-
69.
No, no,
and
not
also
only
not
that.
available. Not only that.
69 applies.
Not only that, sir. Not only that. 71 is not
Just
only.
read that section. Just read that
just
section.
One, just 1 minute.
Kindly read that.
Section
Yes,
71.
of course. Of course. Excellent. They,
You may,
if the attesting witness
71, please. Babu, please.
If the attesting witness does
If
not
the
deny, I mean
attesting
denies or does not
denies
recollect.
or does not recollect the execution of the document, its execution may be proved by other evidence.
Yes.
It's clear. Either the witness should deny or he does not recollect. The other thing is in 69 when he is not found is in 69. When you read 69.
you may be referring
of course.
73. 73 is
Comparison.
comparison
73 is comparison.
By court. By court.
by the
Four.
45 is there. 45 is there. 47
45 is
are,
the
47 is
47
there.
and 45.
Sir, one doubt with regarding to that fact, the recent decision. I am not able to raise the full text of that. Supreme Court 2020 ആണ്.
yes.
One RCR, same situation. I think the full text is not available. Indian Evidence Act Section 71, Indian Evidence Act Section 71, 63 will proof of execution. The operation of provisions held that the resource to Section 71 of Evidence Act is impermissible without the examination of witnesses. Section 71 in Evidence Act would come into operations once and if all the attesting witness deny or do not recollect the execution of the will. The recent decision 2021.
That is the Dhanbak versus Fiora.
Yeah. Justice Nageshwar Rao and Hemant Gupta.
That is not in only Manu also. Manu SC 330 of 2020.
That is
It
if
is in KLJ also 2020 to KLJ.
supposing there are two attesting witnesses alive and one of them is summoned and he denies execution, every endeavor should be made to examine the other witness also.
Yes.
Then only you can resort to the other provisions in the Evidence Act.
Yes, sir. Thank you, sir. Thank you very much.
So before we conclude, we got a question. Is transfer of life interest an illegal act as it is against the wish of testator? Name is not there. It's instrument name 55A9FEB.
Unless it is the wish of the testator, how can there be a life estate?
So before we conclude, can I request the moderator of the day, Sasidharan sir, to have the final remarks?
Summing up.
Today it was a very interesting session. The work done by Mr. Mohankumar was extensive and he had beautiful presentation. And Justice Shyamkumar and Justice Kamal Pasha all had taken active parts. All the other viewers also had taken.
Thanks, sir. Thanks.
Thank you very much, sir.
Thank you for seeing at least online. Yes, I am happy. I am happy seeing you online.
Sir, Sasidharan sir, to be very frank with you, others were just wondering how I persuaded you to come over here. I said I showed a gun.
Even I asked him. Did Justice Nambiar agree?
Because when I heard that you are the moderator, I felt that I am privileged.
Definitely.
I used to sleep this time.
Today I forfeited his sleep. So that brings us to the end of the 43rd session. And tomorrow in the 44th session, we have Justice Sunil Thomas sir with the specific performance of contract with a special reference to the Amendment Act of 2018. That's tomorrow at 3:30. Till then, take care, stay safe.